Today let's discuss three things that you need to know to win your Baltimore accident case. There's a recent decision by the Maryland Court of Appeals that actually came down last week. It's called the Coleman case that made me think that it's time that we should write something short to give our clients and people out there who are looking at our site some guidance on what they need to know to prevail in a case. As a result of this decision, it is clear that in Maryland and actually some of the other jurisdictions around us, it is harder to win and recover for damages in an auto accident case than in most other states in the entire country. So let's go over the three things that you need to be aware of and basically how to counteract them. The first is Maryland recognizes the doctrine of contributory negligence. What it means is if you're simply 1% at fault, you cannot recover in an accident. Coleman last week, our Maryland Court of Appeals, basically said that's the law in Maryland. A lot of trial lawyers, the trial lawyers who actually pressed that case and pushed that case, they're shocked, they're surprised. Our firm's not. In fact, the Court of Appeals decided that case 5-2 in favor of the contributory negligence doctrine. So it's no surprise to people in our law firm that that's where the law is, that's where it's going, and as a result, our clients and people who work with us aren't surprised either, and they know how to react. And the first thing we tell you is because that's the doctrine in Maryland. If there is any possibility of a dispute, don't talk to the carrier. Don't talk to the carrier. Don't give a statement. Don't give a written statement. And most importantly, never give a recorded statement without an attorney present. Other law firms will tell you you can talk to the carrier. Maybe you can give a statement to the carrier. These other law firms are basically not aware of how dangerous the doctrine of contributory negligence is. Point two, you have the burden of proof in all these cases. In other words, it's your burden to show more likely than not 51% to 49% you have to show to prevail in a case. If it's a tie, you lose. Therefore, change of lane cases, cases where it looks like it's one person's word against the other, you need the witnesses. Don't leave the scene without getting the witnesses because a tie makes you a loser. Point three, it does matter when you treat. Insurance companies look at that because juries look at it and judges look at it. After an accident, if you're hurt, go to an urgent care or go to the hospital because gaps in treatment do matter. Gaps in treatment indicate that you might not have been all that hurt because injured people go to the doctor.